Okay, let's raise the big questions here. Bilkis Bano case, embarrassment for the Gujarat government and the Union Home Ministry who granted this remission. Who should be held accountable? What will it take to bring closure in this case? Those are some of the questions we'll raise. Joining me now, Rishi Malhotra is lawyer who appeared for one of the convicts in the Supreme Court in the Bilkis Bano case. Vrinda Grover, senior advocate and someone who's been championing the cause of Bilkis Bano in the courts. Miran Chaddha Borwanka, former police commissioner of Pune and senior IPS officer. And Pramila Desargi, advocate, Karnataka High Court. She's also been a BJP and women's rights activist. Appreciate all of you joining us here on the show tonight. Vrinda Grover, to you first. Do you believe that this is an order which should lead to some element of accountability, and if so, who is accountable according to you? Because the critical question is, if a fraud has been committed, as the Supreme Court is saying, who is responsible according to you for this fraud, and what happens really to those who allowed the remission to go ahead?
Deep, first just to say I appeared in the Supreme Court on behalf of the IPS officer Miran Chaddha Borwanka and other such officers. In terms of who is responsible and accountable, actually the judgment has stated so very clearly and specifically. And it is possible that a convict may come to court and try to suppress certain facts and try to hoodwink the court. And in that petition, in that case, there is the state. The state is present, the state of Gujarat in this particular instance. And the court has said that it was an obligation on the part of the state of Gujarat, therefore, to take the necessary consequent legal steps if where a fraud has been played upon the court. And that step was in the form of a review petition, which the state of Gujarat failed to file. In fact, the court has used very, very clear terms. It's a scathing indictment of the state of Gujarat. And it has said, and I quote from the judgment, instead, the state of Gujarat has acted in tandem and was complicit with the petitioner respondent number 3 herein had sought before who had come before the court in the initial round where the May 2022 order was passed. So it is the state of Gujarat which is also being held responsible and accountable. Because if rule of law has to prevail, who has the primary obligation? It is the state. And in this case, the court has in fact highlighted that too, that there were facts and circumstances which led to the transfer of the investigation to CBI and trial to Maharashtra. In those circumstances, again, the state of Gujarat is acting in a way which is not with an even hand. It has usurped the power of the state of Maharashtra to grant this en masse remission, which is even otherwise vitiated on many counts. Here, of course, the court said that they had no power, this order that cannot stand, and so it's quashed. But even otherwise, the manner in which it was conducted, if there was a negative opinion, say of the special judge Mumbai, that is overlooked. The fine is not paid, a fine that is directed by a court judgment. The fine is not paid and the remission is granted. It is the state of Gujarat's complete complicity with the mob and the men accused of mass murder and gang rape during the targeted violence of 2002, which is the hate crime against Muslims, which the Supreme Court has underscored again today.
Before I go to my other panelists, let me just get one more clarification from you. The fact is, in May of 2022, the same Supreme Court allowed a committee to be set up by the Gujarat government to review this, to go ahead with the possibility of remission. So was the Supreme Court in the dark at the time? Did the Supreme Court not recognize that Gujarat perhaps was not the only state which had the right to grant remission? Gujarat government said we are going under a 1992 policy of our state. Should the Supreme Court have intervened at that stage itself? 2 years these convicts have been out.
That is precisely what this judgment actually clarifies in details, and it's a point-wise inference, as the Supreme Court judgment calls. It was a different bench of the Supreme Court, of course, before whom one convict, Radheshyam, had gone, the same person had actually approached the Gujarat High Court. Gujarat High Court said the appropriate government is the Maharashtra state. Go to Maharashtra. After that order was passed, he moved an application for remission before Maharashtra state. A few negative opinions started coming from the special judge, from the director CBI, etc. At which point, an Article 32 petition, not against, there is no challenge, no appeal against the Gujarat High Court order. A new petition is filed where there is a misrepresentation being made. And it said, oh, Maharashtra High Court says one thing, Gujarat High Court says one thing, I have a right to remission. Who should I go before? Who are the two parties before the Supreme Court at that time? Bilkis Bano is not arrayed as a party. The only two parties is this convict who's seeking that he has a right to remission, and there is the state of Gujarat. The state of Gujarat, interestingly, points out that both as per section 432(7) of the CRPC, as well as the Sriharan judgment, which is a constitution bench of 5 judges, the appropriate government has to be the state of Gujarat. The Supreme Court bench passes an order saying, let the state of Gujarat decide. It is an erroneous, wrong order. What is the state required to do? And the state does it very often when it does not actually like a judgment. Here, the judgment is per incurium. It is against a judgment of a larger constitution bench. The state of Gujarat remains conveniently silent and does not file a review. The Gujarat High Court was not informed of the Supreme Court bench was not informed of all the facts. There is a suppression of facts. And that is why the court has said a fraud was played by suppressing facts, misrepresenting facts before the earlier bench. And that's why that order is today a nullity in the eyes of law.
Okay, I take your point. Let's come to, I'll come one by one to each of you, because Rishi Malhotra, you appeared for one of the convicts in the Supreme Court in the Bilkis Bano case. Did you all suppress facts? The fact was there was a 1992 policy for remission which was replaced by a further policy of the same Gujarat government in 2013 that made it clear rape convicts will not get remission. But facts were hidden from the Supreme Court. We can question whether the Supreme Court should have done more to find out the reality on the ground in May 2022. But the bottom line is the convicts who appeared in the court appeared to act in tandem with the Gujarat government in hiding facts from the Supreme Court.
Rajdeep, let me begin with this, that we have highest regard of the judgment pronounced by Supreme Court. But the irony is that I really fail to understand. I've seen the entire judgment in the evening. Where is the fraud, so-called, I would say, quote-unquote, fraud played by any of the parties before the Supreme Court? As my friend herself suggested, that the Gujarat government took a plea that the appropriate government has to be state of Maharashtra, rightly negated by the Supreme Court, according to us. And Supreme Court said categorically, no, it has to be Gujarat government and it has to be 1992 policy which has to be applied. If my friend and Bilkis was so much aggrieved, she filed a review petition before the Supreme Court. Forget states should not have filed or states should have filed a review. Bilkis filed a review against this judgment of May 2022. That review was rejected. She could have filed a curative before the Supreme Court, which goes before a larger bench of 5 judges. She never chose to do so. Instead of what she does? She files a writ petition challenging a Supreme Court judgment in a writ petition. Now, this is absolutely not maintainable. As my friend said, that a writ against the High Court judgment is not maintainable. So therefore, writ against the Supreme Court judgment per se is also not maintainable. But irony is that there is a complete legal fallacy because Supreme Court has sat over a legal judgment. It may be right, it may be wrong, it may be totally erroneous. But the remedy lies somewhere else, not a writ petition challenging a Supreme Court judgment itself. Point number one.
Sir, we are getting mired in. No, sir, 1 minute. Yeah, go ahead. Please go ahead.
My point is that I really fail to understand that where was the occasion for the Supreme Court in today's judgment to say that the May 22 judgment was vitiated by fraud played upon the court. There was no fraud played, absolutely. Both the orders of the High Court were placed before the Supreme Court in the writ petition. one pertaining to Gujarat High Court, which says that no, you go to Maharashtra, and Bombay High Court order of some other co-convict, which says that you go to Gujarat for remission purpose. Therefore, a writ was filed in Supreme Court that for which government is the appropriate authority to grant remission in this case. So in case the Supreme Court passed an order in May 22 saying that it has to be Gujarat government, for which a remedy was taken by Bilkis to file a review which got rightly dismissed, I really want to raise the question of fraud being played and raise the question of writ being filed against the Supreme Court judgment itself.
I'll tell you just a minute. Okay, just a minute. You know, we will get mired in technicalities, but let's give the hard facts. The hard facts is that the manner in which the remission took place is where the questions are being raised, Pramila Desargi. Because what happens, the Gujarat government quickly sets up a 10-member committee. The committee includes 2 BJP sitting MLAs. It includes 3 other members also who are associated with the BJP. All of them come together and before the 2022 Gujarat elections choose to grant remission. And that is where questions are being raised. There is the question of whether the court, Supreme Court, was given the full legal facts of the case. But there is also the question of the way this played out politically. And then when they are granted remission, guess what? And I'll play those pictures in a moment. They are all these convicts in a rape and murder where 14 people were raped and there was murder. They are being garlanded. In a gang rape and in a case of murder, you've got the convicts being garlanded by the Vishwa Hindu Parishad officials. So naturally the question arises whether all this was settled in some way, and guess what? The Union Home Ministry had concurred in the remission order.
Absolutely not doubted that. And what's wrong if they have been garlanded after 15 years?
Yes, go ahead. The fact is, Mr. Malhotra, I'll come back to you. Go ahead, Ms. Desargi.
You see, the question is who is accountable?
Please go ahead.
The main question. Who is accountable? It is the court which directed the Gujarat court appointing a committee and go ahead. Who is behind it? If only the Supreme Court had said the Gujarat court had no jurisdiction, it is only the Maharashtra court which has the jurisdiction, it should have been decided. There is a conflict of judgments by the Bombay High Court and the Gujarat High Court. When the matter goes to Supreme Court, who has to decide? Ignorance of law is no excuse. Be it the Supreme Court judge or any other judge. Maybe it is Gujarat High Court or Bombay High Court or Supreme Court. Basically, the highest court of the law is the Supreme Court. Supreme Court, it should have said, this is the law. They are not blind sitting judges. Just cannot hear what the other side says. They must apply their law, they must apply their mind and decide what is the law that has to be laid. Because under Article 141, it becomes the law of the country.
Ma'am, please tell me you're not... Ma'am, you are both a lawyer. Ma'am, just a minute.
Supreme Court.
Pramila Desargi ji, you are both a lawyer and you've been a politician. The question arises, look at the manner in which the remission is granted. As I said the moment, the Supreme Court gives the Gujarat government the right to look at remission and committee is immediately set up. That includes only, that is dominated by BJP sitting MPs, MLAs rather.
Please don't bring the party in the arguments. It is not the party. Whoever may be the member, he may be a member of BJP or he may be a member of EHP or maybe any other member. Who constituted? At whose instance the committee was constituted? Supreme Court could have taken notice. Yeah, look here.
Ms. Desargi, when you have convicts who are raped, who are guilty of rape and murder being garlanded by the VHP, when you have a sitting BJP MLA who is part of the committee calling it that this is they were very sanskari people, they are very cultured people. What's the message that went out? Today the court has actually acted against what they believe was a misuse of your remission power. A remission is supposed to be done with due consideration. That was missing in this case. Instead, it was seen to be a political act. Now, you can argue whether it's an act of fraud, but it was clearly seen to be a politically partisan act.
I don't say that. Has anybody challenged the constitution of the committee? Was it before the Gujarat High Court or before the Maharashtra High Court or before the Supreme Court? when everyone kept quiet, and when after the remission, you are taking action. I agree with you. The manner in which the remission was done, and they don't deserve. The rapist can never get the remission. That is my personal opinion. I can't stand with them. See the victory, now today's judgment, we have victory not for Bilkis Bano, but it is for the women of this country. Women of this country, we don't tolerate any rape, and much less any less punishment. They deserve the punishment, and they should not have been given the remission. That is regarding the process. But we are concerned with the law of the land. That is where I am concerned. The Supreme Court blindly passed the judgment in 22. It was wrong. So hold them responsible. Hold them responsible. And they must be made accountable. That you can't simply quite, no, Supreme Court did. They are not above board. They are also bound by the law.
Can I for a moment bring in at this point, can I bring in Miran Chaddha Borwanka at this point? Miran Chaddha Borwanka, you want to respond to what you are hearing? Because there's a sense that the role of the police in the manner in which this has happened also comes under question. We are now 22 years after 2002, and a lone woman has to continue to fight for justice. What does that say about our criminal justice system?
So Rajdeep, as far as criminal justice system is concerned, police wing investigates, and in 90% of the cases, we charge sheet within the time. The trials are pending with the courts. And the first two speakers have already talked about the Supreme Court, and the third speaker in your panel has also talked how the first order of May 2022 caused the whole confusion, giving the right to decide to the state of Gujarat, and now the Supreme Court is saying that Gujarat state had no jurisdiction and the order is a vitiated order. But in this whole rigmarole, we lose sight of the fact that Bilkis Bano lost her 3-year-old child. She was gang raped, 2 other gang rapes, 14 people murdered, including her 3-year-old child and 7 relatives. Do these 11 convicts justify, is remission justified? Let's ask that question. I feel this particular offense is an offense against humanity. I don't think it's a single individual murder. I feel remission at no instance was justified. And now we are talking only of procedures. Let's talk of the victim. Let's talk of the message we had given to our own women in our own society. Does any person, whether it's a man or a woman, feel that these 11 convicts should have been given remission, least of all to have been garlanded, welcomed, and being portrayed as some kind of saviors? Why aren't we discussing that?
Let's raise that. But before I raise that, and I'll raise that in a moment, but before that, I want you to hear what Bilkis Bano told me in 2017. Remember, she was gang raped. She saw in front of her eyes several of her family members being murdered. Listening to what she had told me then about how difficult it was to ensure a conviction.
15 साल में हमको बहुत दुख झेलना पड़ा. कितनी बार घर बदला हमने, और छोटे छोटे बच्चे को लेके सामान इधर उधर करो, बहुत सारी तकलीफें हमको हुई है.
और 15 साल में कभी ऐसा लगा आपको कि शायद मुझे न्याय नहीं मिलेगा, जिन्होंने मेरे खिलाफ ये अत्याचार किया है वो रिहा हो जाएंगे, वो बच जाएंगे? कभी ऐसा लगा कि सिस्टम जो है उसमें मेरे लिए कोई जगह नहीं है? कभी उम्मीद आपने छोड़ी थी?
नहीं, मैंने उम्मीद नहीं छोड़ी थी, क्योंकि हमारे इतने सारे, मेरे परिवार को मार दिया, मेरी बेटी को मार दिया, तो कैसे उम्मीद छूटेगी?
लेकिन अभी भी आप कहती हैं आपको बदला नहीं चाहिए था. आप नहीं चाहती थी कि जिन्होंने ये किया आपके खिलाफ, उन पर आप बदले की भावना से नहीं कर रहे थे, आपको केवल न्याय चाहिए था.
हाँ, न्याय चाहिए.
यानी क्या चाहिए था? कि ये लोग जेल में रहें, इनको सजाए मौत हो, क्या चाहिए था?
वो लोग जेल में रहे, उनको ऐसा याद आवे कि आज हमारे गांव के लोग कितने परेशान थे और हमने कैसे कैसे मारा है, माँ बहनों को, बच्चे को।
इन 15 सालों में आपने मुझसे अभी कहा कि आपको घर घर भटकना पड़ा।
हाँ।
एक घर से कितने घर बदलने पड़े?
बहुत घर बदलने पड़े, 15-20।
डर के मारे?
डर के मारे, क्योंकि जो आरोपी थे हमारे केस के, उनको बार बार पैरल मिलती थी। वो आते थे, मीटिंग करते थे वहाँ पे, हमारे जो लोग रह रहे गांव के, उनको डराते थे और मेरे पर भी दबाव डालते थे। वो आके कहते थे मुझे कि तेरे को ऐसा कह रहे, ऐसा कह रहे।
वो चाहते थे कि आप केस वापस ले।
हाँ, वापस ले।
You know, Vrinda Grover, to take off therefore from that interview I did with Bilkis Bano and what I just heard from Miran Chaddha Borwanka saying, focus on the fact whether a rape convict or someone accused of gang rape, convicted of gang rape and murder should get remission in the first place. There will be those who will argue, and I'm sure Mr. Malhotra will be among them, that they've spent 15 years in jail. And therefore, under the laws of the land, they are entitled to apply for remission. Why should that have been seen as an act of fraud? Or indeed of politics? You could argue that this was done before the Gujarat election. The BJP government in Gandhinagar, the Union Home Ministry, both have questions to answer. But there will be those who will say every convict is also entitled to apply for remission.
Totally right, Deep. I have no difficulty in saying that remission is the right of every convict, and every convict has the right to apply for remission after the mandatory period, which according to the Gujarat 1992 policy was 15 years. If we go to the state of Maharashtra, it will not be 14 years. The court is not saying they don't have a right. The court has actually rooted its judgment in law, constitution, and philosophy. And therefore, they will have a right, but go to the appropriate government. You cannot be playing in tandem with the state. I want to read out here, there is actually a statement released by Bilkis Bano today, and I think her voice should be heard. I'm going to read the statement that has been shared after the passing of the judgment today. Today, and this is Bilkis Bano's statement issued through her lawyer, Shobha Gupta. Today is truly the new year for me. I have wept tears of relief. I have smiled for the first time in over a year and a half. I have hugged my children. It feels like a stone the size of a mountain has been lifted from my chest, and I can breathe again. This is what justice feels like. I thank the Honorable Supreme Court of India for giving me, my children, and women everywhere this vindication and hope in the promise of equal justice for all. I have said before, and I say again today, journeys like mine can never be made alone. I have had my husband and my children by my side. I've had my friends who have given me so much love at a time of such hate and held my hand at each difficult turn. I've had an extraordinary lawyer, Advocate Shobha Gupta, who walked with me unwaveringly for over 20 long years and who never allowed me to lose hope in the idea of justice. A year and a half ago, on August 15, 2022, when those who had destroyed my family and terrorized my very existence were given an early release, I simply collapsed. I felt I had exhausted my reservoir of courage until a million solidarities came my way. Thousands of ordinary people and women of India came forward. They stood with me, spoke for me, and filed PIL petitions in the Supreme Court. 6,000 people from all over and 8,500 people from Mumbai, etc., etc. To each of these people, my gratitude for your precious solidarity and strength. You gave me the will to struggle to rescue the idea of justice, not just for me, but for every woman in India. I thank you, even as I absorb the full meaning of this verdict for my own life and my own children's lives. The dua that emerges from my heart today is simple: the rule of law above all else and equality before law for all. This is the statement issued by Bilkis Bano, and Shobha has just joined us.
I just want to stop. I just want to stop you for a moment because Shobha Gupta has just joined me on the show, and I want to tell our viewers that Shobha Gupta is the woman who has stood by Bilkis Bano through thick and thin. It isn't easy to stand up for someone who is, in a way, seemingly lonely. So Shobha Gupta, I want to ask you today, what does this verdict mean? You have stood up against the might of the state and you have won this battle today in a way. What does this day mean for you, Shobha Gupta? What does it mean? We heard Bilkis Bano's statement, but as her lawyer, as her friend? What does this mean?
It means a lot. Actually, great sigh of relief for me as well. I was bearing huge burden on my shoulders and can't define it in words how much weighty it was. Battle was tough, but Bilkis, I always say, you know, she is a pillar of strength. And if you are working for her or working with her, she gives you that energy. She gives you that assurance. So maybe you draw energy, you draw source from her, and you can work. Yes, battle was tough, but the end result is so good, and I'm sure you must be very happy. You have been through Bilkis's battle all throughout, and you have just
I want to tell our viewers, ma'am, Shobhaji, I want to just tell viewers, as someone who covered those riots, who met Bilkis Bano at the time, I mean, anyone with any ounce of humanity in them, if someone has been gang raped and members of our family have been killed before our eyes, will you not seek justice? So I came from that perspective. But what I want to understand is the question that Miran Chaddha Borwanka has raised, that why should they have got remission at all? On the other hand, there will be the likes of Mr. Malhotra who will say, look, 15 years have been served. What will you tell those who will say, look, they've served their punishment, it's time for closure?
Rajdeep, they have, this is a case where a pregnant woman has been gang raped. Her mother in front of her eyes gang raped and murdered. Her firstborn child brutally murdered. 14 members. All familial network has been completely erased. How come 14 years would be, 14 years imprisonment would be justifiable, would be enough, would be something someone say they have served 14 years. If a person murders only one person, he would have to undergo minimum 14 years. A case like this, when they had shown no sign of humanity, they crossed, like I have done this matter for 20 years. Still, I am short of expression to express how barbaric the crime is. You add all the possible terms of barbarism, inhuman, egregious, club all of that, and that crime is even not sufficiently expressed. This is a case where remission, as Vrinda ma'am said, they have a right to ask for. But this is not a case where the remission should travel to them. And that's why all stakeholders said no. That's why all stakeholders... Yeah, you're saying something.
No, you're saying all the stakeholders therefore thought that this was a crime that deserved the maximum punishment, which was life, which means life and not remission. Am I correct? That you believe that therefore there was no question of remission, especially as these were powerful people, influential people who had been repeatedly granted parole. Am I correct?
Rajdeep, forget. Assume they are not powerful. But the point is, what message you are sending to the society, what message you are sending to each citizen in the country, that how do they feel safe? If people who commit such kind of barbaric crime and can come out like any other murderer, had it been a simple gunshot murder, the convict would have come out after 14 years saying, you please consider me for remission. Now, consideration, asking for consideration and to be granted are two different things. What are the considerations? How would you really justify granting them or giving them the same treatment which would have meted out to a person who would have committed a very simple single murder? How are you justifying somebody
I
like
take
the
your
system
point.
is justifying?
I take your point, Ms. Gupta, and I just for a moment want to take that to Mr. Malhotra, because Mr. Malhotra, you have been
I don't
arguing in the past on my shows that they had done their 15 years. The fact is, Mr. Malhotra, they may have done their 15 years, but they had repeatedly got parole. They were extremely powerful and influential. They were obviously people who had connections with the government in Gujarat, and it would seem that the Union Home Ministry also concurred with the Gujarat government on them. The crime itself was as heinous as it can get. Gang rape and murder. Cold-blooded murder. Now, can that be, Mr. Malhotra, reason enough to give remission in such cases?
You see, please do not forget, even today's judgment of Supreme Court has recognized that they have a right of remission. Only thing which they have varied is that instead of approaching the Gujarat government, they need to approach the Maharashtra government. So remission has never been snatched by either of the Supreme Court judgment, number one. And I have been telling in your channel and again different channels that once the policy stipulates, which is a 92 policy at that time in Gujarat, which stipulates that for consideration of remission, there are twin conditions. One is they must serve actual 14 years and they must have a good conduct in the jail. So post-jail conduct, if they have been garlanded or if they have been victorious enough to show these signs and all that, that is not the material for consideration for remission. If they have a good conduct, which the jail authorities have certified in this case, all the files are before the Supreme Court, all the original data was before the Supreme Court, they have been granted good conduct by jail authorities for overall 15 years. That was the requirement under the 92 policy. And therefore I said, once the Supreme Court has held in 2022 that a policy of Gujarat has to be applied. Today, we have two judgments now of Supreme Court, one saying Maharashtra, one saying Gujarat. Supreme Court say that...
Yes, but Mr. Malhotra, Mr. Malhotra, look at the way the Gujarat government then goes ahead and sets up a committee consisting of BJP MLAs, consisting of BJP members. When you know that many of these,
just a minute.
Many of these MLAs have links to the are alleged. No,
just a minute. That's only
a 10-member committee, Mr. Malhotra, is set up. That committee. No. The fact is, when a committee is set up to look at remission, it should be an independent committee. It should be an independent committee. It should not be a committee which already has a preconceived notion that these are sanskari Brahmins. I mean, that's the problem. You can't have a committee which is, it almost seems as if the entire process is rigged. Miran Chaddha Borwanka, you asked the question, why should they have been granted remission? My point is, everyone is entitled to apply for remission. It's the manner in which government committees are set up to either slant the verdict one way or the other, which is where my problem is. Would you agree with that?
No, let me interject. Just see the judgment of 280 odd pages, not a single line on this aspect at all casted by Supreme Court. It's all media speculation that MLAs and advisory committee consist of partition stakeholders. Not a single line doubted by Supreme Court in its entire judgment today.
Okay, so I am raising that question. The Supreme Court has called it just a minute, sir. Supreme Court has called it an act of fraud. Right, but Miran Chaddha Borwanka, is that part of the problem? That the state itself could be hugely partisan in cases like this, and that's why public confidence and faith in the law is diminished.
Absolutely. So states, instead of following the rule of law, are being out and out doing favoritism, as we can see in the over-enthusiastic response of the state of Gujarat. But my point is that a convict may have and indeed has a right to seek remission. But the government, while granting remission, should appreciate the gravity of the offense, which I feel in this particular case was so heinous, so serious, so grave, that remission should not have been granted, one. And if 1992 policy of Gujarat says that remission can be granted in such cases also, then the policy needs to be thrown away. New policy should be drafted. Otherwise, women are definitely not safe. And if Delhi gives death penalty in Nirbhaya case, then why we are being so soft in this particular case? That is also my question.
Well, that is a question that obviously is a question that should haunt many people out there. Pramila Desargi, let me give you a comment there. Would you agree with what Miran Chaddha Borwanka said? When there is public fury and people say Nirbhaya's killer and Nirbhaya's rapists and killers must get death penalty, and that's what they get because the entire country is agitated. But it doesn't happen with Bilkis Bano, a hapless woman in a village of Gujarat. Would you agree that the law must be the same for all? Every Indian has equal right. It cannot be that a gang rape in Delhi results in the death penalty, but one in Gujarat does not.
I agree with you. What we want is justice according to law.
Mr.
You can't go in a highway. We are not in the Banana Republic. We have a law and rule and regulations. We are bound by it. We are bound by the rules framed. If you are agreed by the rules, ask the parliament to change the rules. Ask the state government to change the rules. So long as the rules are there, so long as the Gujarat government has got the power of remission, so long as the rule stays, unless it's changed, they have to act according to law. We see, the criminal jurisprudence, we have a reformative theory and also retributive theory. Which you want? Don't you want your citizens to reform? You do not want them to reform in the society?
So you are going to garland convicts?
As criminals only?
So reform, so you reform society, Miss Desargi, just a minute. Miss Desargi, no one reforms society by garlanding rape convicts. A society doesn't get reformed by garlanding rape convicts. Let's be very clear about that. There is no place in a civilized society for rape convicts and murderers to be garlanded because they are politically aligned.
Every day we see
I hope you recognize that and appreciate what I'm saying.
Who are arrested and they are brought out. They are doing it. You see that. See, the law must be. You do make a law. The convict who come out of the jail should not be garlanded. It should be treated as an offence. It is not material.
Okay.
You tell them. The family members, the kith and kin, friends, they just want to garland. Who are you to prevent it? Who are you to prevent it? Have you any right to prevent it? Is there any law that's prohibited?
I am no one. I am no one. I am not a politically influential person.
It's not good. I agree with you. See, it may not be good. It may not be good
okay.
for you and others.
Okay.
But it may be good for others.
Can I just bring
Bentham's theory. One man's good is another
this
man's
was
bad.
not. Let's be honest, producer. Okay, I'm running out of time. All I want to say is that for the longest time, the Supreme Court has been, in recent times certainly, been questioned for not exercising enough moral power, for not restoring the faith of citizens that justice is equal for all. Whether you're a Bilkis Bano or whether you're a Nirbhaya or indeed any woman who is gang raped and sees family members, in this case, being murdered before her eyes. Equality before the law, free of any political bias or partisanship, simply because you have power in a Gandhinagar or in Delhi, that cannot be reason to grant remission. Remission must be purely on the facts of the case and must be equal for all. That's the principle in a way that the Supreme Court has enunciated today and hopefully restored some faith in the rule of law.